not color.
All right, we've got 8 bills on the voting list, and we'll start off with Senate Bill 765, which is Senator Sidnor. It's been withdrawn, so the motion's for an unfavorable withdrawn. Is everybody okay? Awesome. Same thing with Senate Bill 779, Senator King. It's been withdrawn. Motion's unfavorable withdrawn. Great. All right, next we'll go to Senate Bill 392. Jamie Lancaster.
This emergency administration bill establishes that a sentence imposed under a plea agreement may not be considered to be compliant with the sentencing guidelines unless the sentence falls within the actual sentencing guidelines range. The bill also expands the reporting requirements for the Maryland State Commission on Criminal Sentencing Policy by requiring the commission to provide in its annual report additional information for cases involving a crime of violence is defined under 14101 of the criminal law article. The commission must also include appropriate entry locations on a sentencing guidelines worksheet for a court to report on this information. There is an amendment included in your voting packet. That is Amendment 703421/1. What the amendment does is it strikes provisions of the bill related to the whether a sentence is compliant or not, and it also strikes provisions related to the new reporting requirement. And on page 5 of 5 of the bill, what it does is it breaks down for crimes of violence for certain information to be reported disaggregated by county, and also by county and crime. So that's below line 11. Below that, in line 18, there is an exception that provides that for a county in which only one circuit court judge sits, the commission shall combine the information reported for the county under paragraph 1, Roman 3, with another county that shares a geographic border with that county. This was drafted in response to some of the concerns from the judiciary and the Sentencing Commission about counties where there was only one judge. So effectively, it would have the effect of being just a report on that one judge. After providing this information to the commission, they noted, just as a practical matter, that there would be several counties where, you would, if you use this language, it would effectively, be pretty identifiable, because it would just be a one-judge county with another one-judge county, and you would just be able to see the average between two judges. So that's where the amendment stands.
Let's do discussion on the amendment. Go ahead, Senator West.
I didn't hear Mr. Lancaster's final words.
Oh, I just said that's where the amendment stands.
Oh, okay, because I'm looking at this sheet of paper we were given.
Sure.
Which looks like it's the judicial circuits. So this bill doesn't refer to judicial circuits.
It does not.
It refers to counties.
No, that's just for information.
Thanks.
Senator Sidnor.
So, just for purposes of understanding that line, which counties are we talking about?
So the Sentencing Commission sent me some information. Let's see, 4 of the 5 jurisdictions in the 2nd Judicial Circuit have one judge. So that, for example, includes Caroline County, Talbot County, Queen Anne's County, and Kent County. So those would be jurisdictions, and I believe it's either Garrett or Allegheny also only has one judge.
Thank you.
I'm not sure, Senator.
Senator Cassidy.
I guess it would help. I mean, it's really not fair to a county even with just 3 judges. Seems to me that we got to be fair. I mean, I preferred each, I was in favor of each judge, but if we're going to pass something, it's got to be fair to all the jurisdictions. And so I think if you're I mean, it would help if we know, like, how many judges are in, look at the First Circuit, the Second Circuit. I mean, the Third Circuit's no problem. Fourth Circuit, other than Garrett County's no problem. Fifth Circuit's no problem. Sixth Circuit, Seventh Circuit, Eighth Circuit, none of those are a problem. The only problem comes in really in First and Second Circuits, probably. Do you know what we have, how many judges in those counties?
I mean, I can find out for you, Senator.
Because I'm just thinking, if we could just say the First Circuit and Second Circuit could each report as a circuit, if we knew what, but I don't know what, I can pull it up on the internet, I guess.
Get a breakdown of how many circuit court judges are in each of the
In each of those
jurisdictions.
In each of those counties, it might just be easier if we say the First and Second Circuit's going to report as a circuit. I don't know if that works, but maybe there's some of those that are pretty big, it wouldn't work.
Sure, I guess to be doing it right, you know, we would, I think, just need a breakdown of how many judges were in each county, so that you could make sure that you were covering all the circuits that you needed to.
Yeah.
Is that available?
Judicial pay things, they always give this to us. Or, I'm sorry, the bills on, give us the new judge, they always list all that out for us. When we approve going from 3 judges to 4 judges and the like.
While I was looking for that information, we'll just, one of the 2 other things that I think were neglected to mention. One is the dashboard, so the last page. The commission shall conspicuously post the information required to be included in the report under paragraph 1, little 3 of this section, subsection 3 of this section, subsection in a data dashboard on its public website. And also, we might want to look into, this is, the way it's drafted, it's now an emergency bill, so we might want to delay the implementation, not make it an emergency bill.
I'm looking at a webpage that lists all that. It tells you, I mean, I can give you those numbers real quick.
Sure, I was actually just directed to the Maryland manual, so I'm looking it up
Well, there's one that
myself.
says, it's a court page, it has Dorchester has 1, Somerset has 1, Wycomico has 4, and Worcester has 3 in the First Circuit. In the Second Circuit, Caroline has 1, Cecil has 4, Kent has 1, Queen Anne's has 1, and Talbot has 1. Cecil has 4. Caroline's 1, Cecil's 4, Kent's 1, Queen Anne's is 1, and Talbot's 1. First Circuit, Dorchester's 1, Somerset's 1, Wycomico's 4, and Worcester's 3. Fourth Circuit, Allegheny has 2, Garrett has 1, and Washington has 6. Eighth, that's Baltimore City. I mean, they have 35. Seventh, Calvert has 3. Charles has 5. Prince George's has 24. And St. Mary's has 3. Third, oh, these are all like 6. Third Circuit is Baltimore County has 20, and Hartford County has 6. Wait a minute, third, I just want to make sure, yes, 6. Third Circuit, oh, it's, which, 6? 6 is Frederick has 6, and Montgomery County has 20, Montgomery has 24. Fifth, Anne Arundel has 13, Carroll has 4, and Howard has 5.
All right, so what if you do this then? You do the First Circuit, the Second Circuit, and the Fourth Circuit by circuit, everyone else by county.
Second.
And fourth.
Fourth,
Yeah.
that works. It looks like a fair way to do it.
Senator West.
The way you could do it is with one or more other counties that share a geographic border, because if you combine Garrett with Allegheny, that's a fair number of judges. If you combine Somerset with Worcester, it's a bunch of judges. You could combine Dorchester with Wycomico and get a lot of judges. And then the one problem you're going to have is Caroline, Talbot, and Queen Anne's, but they all share common borders, all three of them. So,
I mean, to me, the only real, if you do it, okay, I hear what you're saying, but if you do it by the first, second, and fourth, the only other county that's out there with 3 is in the Seventh Circuit, which is Calvert and St. Mary's. But that's 3. I don't know. Gotta draw a line somewhere.
Any jurisdiction with 3 or fewer can be combined with another jurisdiction of, fewer than 6.
The answer was 1. Are they worried about 1 judge? Why are we worrying about 3 now?
I'm just trying to be fair to the,
Man.
if major jurisdictions, those judges hide within 35 and 25 and 20 judges, then you got the smaller jurisdictions, they're just like 2 or 3.
I know, but you're still, like, we're going backwards away from, when you're at counties, you're closer, and then the further we get away back from, I mean, maybe you wanna, I'd like to know, and I'm sure the people in the
Well,
rural,
I'd
I'm sure
like
people in
to
the
know-
rural counties wanna actually know this. They don't wanna be hid, they don't wanna hide them. I mean, ask the TIS counties.
Yeah, you got some jurisdictions with 13, 24, 24, 35.
I mean, I see what you're saying about the fairness, but you're making it less transparent if we're
Yeah,
sticking
I
them
mean,
in
look, I
there.
wanted transparency, but then if you're not gonna get that, I'd like to have at least a little bit of parity among the judges.
I would just guess that the people in the rural counties would want the more maximum transparency, not the parity argument.
It is cleaner if you do Second, Fourth Circuit, circuits, everyone else by county.
That's fine with me.
All right. Okay, so let's adopt the amendment before us, and then we're gonna have to amend the amended version with what we just decided. So, let's adopt the amendment. Is everyone okay with that? Okay,
I think I
great.
gotta vote against,
No, I don't want to be,
yeah, we gotta report.
Okay,
against
you'll
it.
get, got it. Okay,
Go
so do
against
you wanna
it.
do a roll call on that?
Yeah, please.
Okay. Well, actually, here, hold on. Against the amendment. Huff, Casley, West.
Okay, well, hold on, so 1,
a quick rundown real quick?
I apologize, can I get a recap?
Yeah, yeah.
Sure. So the amendment strikes provisions of the bill, and if you turn to page 505, in the reprint, below line 11, what it does is it says that for crimes of violence, certain information needs to be reported disaggregated by county. So that's the number and percentage of sentencing events in each disposition category, the number and percentages of sentencing events that resulted in a departure from the sentencing guidelines, and for sentences that resulted in a departure from the sentencing guidelines, the departure reason cited. Then for each crime of violence, the report needs to have disaggregated by county and crime, the average total sentence, the average non-suspended sentence, and for sentences in which a portion of the sentence was suspended, the average percentage of the total sentence that was suspended. There's also a part of the amendment on the next page, if you flip to the back, that requires that the commission conspicuously post the information that's required to be included relating to crimes of violence in a data dashboard on its public website. So I guess currently, just the committee was discussing an exception that's back on page 5. So certain counties have a small number of judges. There are a couple of counties that just have one circuit court judge. So there's an exception in the reprint. As it's drafted, it would say that the commission would combine information for a county that only has one circuit court judge sitting in it with another county, information for another county that shares a geographic border with that county. But I guess there's an amendment to the amendment that broke down just which judicial circuits have a small number of judges.
There's actually 7 with only one. You said a couple, there's actually 7 with only one judge.
Okay, so more than a couple. So there's 7 jurisdictions with one judge. So it would say that the first, second, and fourth judicial circuits should be reported by circuit instead of at the county level.
What we're doing is we're going to do a roll call on the amendment, and then we're going to add an amendment to the amendment, or can we do this all as one amendment?
I would do it,
Amend the amendment?
yeah.
Okay. So we're going to adopt, the motion is to adopt this amendment. We have 4 votes in the negative. Senator Castley, Senator West, Senator Bailey, and Senator Huff are in the negative. And we're all good for adopting the amendment? Okay, great. Now, the bill's before you as amended. There's an amendment to that amendment, to the amended bill, which is, just read it one more time.
Right. So first, second, and fourth judicial circuits, for those counties, the commission would report by county, or excuse me, by circuit, not by county. And, right.
So, amendments before you. Is everyone okay with that amendment?
Effective date?
And then, okay, it's okay. Huff is a no. Senator West is a no. Senator Bailey's a no. Okay, and then there's another amendment, which pushes the effective date back, because it's an emergency bill right now. Just push it back to October 1st, 2023, or 2022.
Why, because they need more time?
It's an emergency bill now, so yeah, let's give a little bit more time to do it, but. Is everyone okay with that?
Yeah.
Okay.
Oh, I'm making it for emergency? No. No on that.
No, take it, it is an emergency right now, so I'm taking it back to just make it a regular effective date of October 1st, 2022. Because right,
I'm a no on that.
okay, got it. All right, now, the bill is before you. I'm sorry, go ahead.
Give me a no on the emergency also.
Okay,
Yeah,
got it.
I mean, I want to know on the emergency also. I want it to be emergency.
Okay, just to be clear, right now it is drafted as an emergency bill. The amendment is to make it a normal effective date of October.
Yep.
Okay, got it.
Oh,
So all three, just to clarify, Kathleen,
I-
Bailey.
I'm okay with that. I want to use it for their election. I want it, emergency.
You want emergency? Okay, got it, okay.
Senator Kathleen,
Okay, so Senator Castley, Senator West, Senator Bailey, Senator Huffer against taking away the emergency aspect of the bill. Okay. Anyone else? I mean, it's up to the committee, whatever you want to do. All right, now the bill's before you with the amendments. The motion, is further discussion? Motions for a favorable. We can do a roll call with amendments.
Senator Lee. Yes. Senator Castley.
Yes.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Watson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. Bill 44.
Senate Bill 44 prohibits a person from leaving a dog outside and unattended for longer than 30 minutes without access to specified shelter or shade during certain weather conditions. There is one amendment in the voting packet. That is Amendment 573320/1. And that provides a change to, if you look to page 3 of 4 in the reprint, it alters the prohibition. So with the amendment, the prohibition would read, except as provided in subsection D of this section, a person may not leave a dog outside and unattended for longer than 30 minutes without access to continuous, 1, suitable shelter during extreme weather conditions, and suitable shelter or suitable shade when temperatures are above 80 degrees Fahrenheit. So that would strike the limit under the bill of 90 and change it to 80, and also strike the exception that followed for below what is required for a heat advisory. There's also a change to the definitional language. Just back on page 1, it changes the definition of what is an extreme weather condition. So an extreme weather condition means temperatures below 32 degrees Fahrenheit or conditions during an active winter weather warning or advisory issued by the National Weather Service. Currently, that just reads an active weather warning or advisory by National Weather Service.
In layman's terms, what currently the bill says, the bill says that if it's hot outside, you've got to have a doghouse. The intent was, the amendment is, the doghouse is for the freezing, just like it's currently in the bill. But when it's hot outside, that shade would be sufficient. And then it also takes the shade, currently it says shade at 90. Seems to me a dog sitting in the sun at 80, a black dog sitting in the sun at 80 isn't very good either. So the intent is just that we don't force people to get dog houses, have a dog house if you're leaving your dog outside in the summer. And it recognizes the reality that a lot of us don't have air conditioning, and it's worse inside than outside, and the dog just wants to lie under the awning, the porch, the shade, whatever it is, in the summer months, and not require people to get a dog house just to have their dog outside in the summertime. But I think most people would not put their dog outside when it's freezing, and if they want to do that, then they should go ahead and get a dog house. I don't want to force people to get a dog house if they're putting their dog in the backyard in the summer, even when it's a heat advisory, because for a lot of us who don't have air conditioning, it's worse inside than outside, and you don't make everybody go and buy the way the bill's written right now. If you have a dog, you got to get a dog house, and we don't want forcing everybody to go buy a dog house. If you want to leave your dog out when it's freezing, you got to get a dog house. But if you just want to put the dog in the backyard under the big oak tree or on the back porch, and it's hot as heck, well, it's hot as heck inside too. Those people shouldn't have to get a doghouse to do that.
Is too much, too broad. 80 degrees, some 80 degrees isn't even that hot. It depends on the humidity. And I think I talked about this before, the fact that there's poor people or people who don't even believe in air conditioning. They might not even be poor. There's like older people. My mother was an older adult. It had to be like 100 degrees when we were little before she let us put the air conditioning on inside. So my point is that there could be a hot box in the house that people are living in, and it's better for them to be outside. So I just think 80 is going too far, in my opinion. I was struggling with 90.
But remember, that just says you gotta have shade in the backyard. I'm just saying, if you put your dog in the backyard, even if it's 80, if it's a black dog sitting in the backyard at 80, that's still, you gotta give him some shade, give him the
Why
back.
does it matter what the race of the dog is?
I knew it was only a matter of time before that happened when I made that joke.
It's not minority dog things, I'm sorry. Okay. I was trying to throw a bone to the advocates, I'm sorry.
Oh.
Anyway, no pun intended. I just, if we're gonna change that, take it to 80, because I just can't imagine putting a dog even at 80 degrees, just put him in the hot sun. You ought to have at least a tree to go under, a big tree to go under, or go on the back porch, something to, not just sit in the hot sun.
Well, without the amendment, this is the identical bill that was passed in the House. So there'll be no problem getting this bill passed in the House if we pass it in the Senate without the amendments. I'm not wild about the 90, about the 80. And I think you're wrong, Senator Cassidy, that the section that has the degrees in it says suitable shelter or suitable shade when temperatures are above a certain amount. So you don't.
That's defined in the first part of the bill as a hot day.
Where's the except?
Under the definitions, extreme weather event means temperatures below 30 degrees or during a weather warning. Well, weather warnings, that's all we get in Maryland, at least in my part of Maryland. In the summer, every day is a weather warning. Every
Extreme
day.
weather conditions, are we talking about extreme weather conditions or weather warning?
It says warning or advisory. Every day, the radio in the summertime is a summer heat, it's a heat advisory. It's Maryland. It's gonna be night.
That's not right. It does not include marine weather.
No, not marine weather. Those aren't marine applies on the weather.
Extreme weather conditions means temperatures below 32
Or conditions during an active.
Senator, I think you're looking at page 1 of the bill. I'm just working off of the reprint, and I'll just read the language that's there as it's drafted. But right, so extreme weather conditions is defined as temperatures below 32 or conditions during an active weather warning or advisory issued by NWS. So that would be cold temperatures or those hot temperatures where you get that heat advisory or warning. Okay.
And through all of July and August, every day, we get a summer heat advisory, every day. Because the heat index, you add the humidity plus the temperature, every day is a heat advisory. So that means you.
I'd like to do an exemption for Baltimore City.
So Senator Bailey and then Senator Lee.
So are we just talking about the amendment right at the moment, or are we talking about the bill?
The amendment.
So, when the amendment's talking about the shade tree, right? And it's 80 degrees at nighttime. I mean, I gotta tell you, I represent a lot of people that don't have electric. I got 3,000 Amish families that have no electric, right? There is no way, it's hotter outside than it is inside, you know, in those those times. So, I'm not a fan of the amendment or the bill.
Let's ask you a question. Okay, Jamie, you're in charge of this right now. Doesn't the state currently require a proper shelter for animals, but there's no definition of what proper shelter means?
Right, so the current animal abuse statute does provide that a person who has, I'm going to paraphrase here, control or custody of an animal can't fail to provide that animal with adequate shelter or protection from the weather,
So they still
essentially.
have to have shelter, right?
So, right, so those terms have been judicially interpreted,
So it causes a lot of
the
confusion
Attorney
if you
General's.
don't know what proper shelter means, right? So I guess these amendments define kind of what a proper shelter would be like.
So there is if you'd like, there's a letter from the Attorney General's office that's been circulating that does
Yeah.
provide the judicially interpreted meaning of what adequate
Shelter.
adequate shelter means under the animal abuse statute as it's currently drafted. I can pull that up for you if you'd like, Senator, but this does provide its own definition.
Okay, that's fine. Senator West, can I ask you a question? Senator West? Yeah. Yeah, hey, Senator West, what was, the 80 degrees, and the below 32, was that?
That's my amendment.
Oh,
Just looking at my amendment.
Well, the bill itself has 90 degrees
is to take it
and
out?
32 degrees. The Castley amendment takes the 90 down to 80 degrees.
why are you doing that? I thought you were against, I thought you were against shelters.
No. So under the current bill, it says that we're all fine with cold weather. 32, I'm not opposing the 32. We're only talking about the hot weather. In hot weather, under the bill as it's written, if your dog is outside and it's above 92 or a heat advisory, you gotta have a doghouse. And a lot of us are saying it's hotter inside than outside. If the dog's in the house, it's worse than it is outside under the big shade tree. So we're just trying to make it clear that those really hot days, you don't have to have a doghouse. It can be in the shade or on the back porch and doesn't have to be in a doghouse in those really hot days. That's all it does. And then as a give to the advocates, I figured if your dog's lying in the backyard without shade and it's 80, that's still pretty bad. I mean, if you're gonna have shade, you always have shade. And the shade will be there whether it's 80 or 90 or whatever. So,
All right, we've spent hours on this bill, and, I can't, the Attorney General's been engaged on this bill. So let's just go ahead and, Senator's office amendment, it's been offered. I have not heard a second. Okay, amendment fails. The bill's before you clean. Motion's for a favorable. We'll do a roll call if you'd like. Let's just go.
now,
We're voting on a clean bill. The motion's for a favorable. It's been seconded. Let's roll it. All right.
Senator Lee.
You mean the bill as it came in by
Yes.
you?
The Senator Lee, it's a bill as, it's as it came in, without any amendments.
As your bill? Okay, yes, okay.
Senator Cassidy.
pass.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Watson.
Yes.
Senator Bailey.
No.
Senator Carter.
My deepest fear is this is sort of an anti-poor people bill. However, I'll vote yes because I think much of it is covered in current law already.
Senator Huff.
Yes.
Senator Cassidy.
Yes. Jesus.
Chairman Smith.
Yes. Let's go to Senate Bill 49.
Senate Bill 49 expands the definition of a person in position of authority under the fourth-degree sexual offense statute. The bill also expands the application of the fourth-degree sex offense statute to include specified individuals. Lastly, the bill establishes that unless specifically charged by the state, a violation of the fourth-degree sex offense statute cannot be a lesser included offense of any other crime. There is one amendment. This amendment was before the committee when the bill was up before it last. Sure.
Yes, there was a work group, Senator Huff, Senator Heddleman, and me, and Delegate Love, as I recall, were on it. And so that's where the language at the bottom of the reprinted page 2 comes from. So that makes sure that if two people are enrolled in college, and one is a senior and one's a freshman, and the freshman's under 18 years old, and they get involved, that's not illegal. So that was the result of our work group. For some reason, however, as Senator Heddleman pointed out last time we talked about this, on the top of page 2 of the reprint, the language, a child care facility, including the after-school program, was deleted. There was no intention that that be deleted. So could I move that we restore that language and then pass the bill with that language, as amended, with that language restored?
Back in, it's been seconded. Is everyone okay with that? Further discussion? Is everyone okay? Okay. So, all right, that amendment passes. Further discussion on the bill? Adding child care facilities back in. We have not passed the amendment. We have not. Okay, go ahead. My apologies. Yes. Yeah, you're right. Yeah, you're right. So, discussion on, these are your amendments, right? Yes. Okay. Further discussion on that. Sure.
Yeah, I don't understand the college thing. I mean, it just seems elitist to me. 23-year-old who's in college gets special treatment. A 23-year-old who's not in college doesn't get the special treatment. That just seems elitist. I can't support that. I mean, no, that was the amendment to the amendment we adopted. We didn't put the amendment on yet.
Because it puts college students to a different standard as regular people? I kind of agree.
Well, as I said, the work group did this. I think it was mostly Senator Huff's idea, which I agreed with, and that is if you have a senior who is supervising freshmen, say, in a lab, and the senior is supervising the lab, and let's say she, be nice about it, gets involved with a freshman male who's not yet 18 years old, and so you do have the supervisory relationship, but they're both in the same college. That should not be illegal.
But if they're both working for Walmart, it is illegal. I mean, right? Yeah, I mean, but if they're both working for Walmart and she's a little bit higher up than he is, and he's a shelf stocker, and she's teaching him how to stock shelves and push brooms and all the other stuff, that's treated different. If you're teaching chemistry, you get exemption. If you're teaching how to stock shelves, you don't.
That doesn't make sense.
He makes a good point. Let's uphold the bill.
Yeah, that doesn't make sense.
All right, several folks are asking for a hold on the bill. So from Princeton to Walmart, we'll cover it. All right, the bill's been held. All right, we'll go for Senate Bill 431.
Senate Bill 431 alters miscellaneous provisions of the Corporations and Associations article, including those related to limited existence corporations, stockholder participation in meetings by remote communication, indirectly owned shares of stock, mergers between parent and subsidiary corporations, and the dissolution of corporations, and it makes other technical and clarifying changes as well.
Chair. You may recall Bill Carlson was here to answer any questions about this rather complicated bill. This is the annual miscellaneous corporate technical changes bill that the business law section of the State Bar Association always brings. And as I say, everybody had an opportunity to answer, to get their questions answered. So I move favorable.
All right, so there's been a motion for a favorable. It's been seconded. Everyone's okay? Okay, great. Senate Bill 468.
Senate Bill 468 clarifies the circumstances in which a personal representative may pay commissions to the personal representatives and attorney's fees without court approval. Specifically, it adds the requirement that each payment be for services rendered by the attorney or representative prior to the date of the written consent to the payment, unless it's filed simultaneously with the final report.
Thank you, Mr. Chair. Another technical bill. You may recall Jonathan Lasley was here from the Estates and Trust section to answer questions about this one. This basically says that if all the creditors and the interested parties have consented to the payment of attorney's fees, there's no need to go to the orphans court and start a legal proceeding to get the orphans court to approve the attorney's fees. So I move favorable.
Did everyone's okay? All right, great. All right, Senate Bill 508.
Senate Bill 508 alters the circumstances under which a court may appoint a guardian of the person for an unmarried minor by requiring the court to find by preponderance that the appointment is in the best interest of the minor, that no testamentary appointment has been made, and that either no parent is willing or able to serve, that each parent consents to the appointment, or that no parent objects to the appointment of the guardian. And finally, the bill clarifies that the appointment of a guardian cannot be construed to require the termination of parental rights.
Thank you, Mr. Chair. Once again, a technical bill. You may recall that former delegate Kathleen DeMay was here and answered questions about this bill. There was no opposition. I move favorable.
It's been seconded. Questions on the bill, further discussion. Everyone's okay? Excellent. Okay, great. Just a real quick, before we just close out the voting session, I think we've got two lengthy calendars on the floor right now. Senate Bill 392 will be probably reported out on Thursday. Will be on the floor. Second reading on
Distribution and second reading on Thursday.
Thursday, and then the rest of these bills will be on Friday. So we got a lot on the floor. I'm gonna try. I'll make a decision tomorrow morning whether we're going to vote after hearings tomorrow, so as to avoid us from voting on Friday. Okay. That's it. Have a good night.